Good morning. This is Gary Wickert with Matthiesen, Wickert Lehrer, and I understand that I've got an audience of American Insurance Association members who want to discuss some of the challenges and trends in workers' compensation subrogation this morning. Thank you for attending. Thank you for the invitation. Normally there's a preamble that we go through with a lot of the rules and procedures for handling the GoToWebinar interface. I understand that Peter Foley, who has attended some of our webinars, is familiar with those tools. And quite frankly, there won't be a need for a lot of use of those, so I'll skip that preamble. If you have questions during this presentation, which I had scheduled for an hour and then Peter indicated we could go a little bit over, I'm really a stickler with other people's time. So normally I would have ended immediately at 1 hour. I will probably go a little bit over. There's a lot of material and a lot of good material that I think the sort of people attending this session will want to hear. Normally when I give a webinar, it's to a lot of the claims folks, the file handlers who may not have much decision-making power when it comes to the industry as a whole, their company, or the manner in which work comp subrogation is handled, but they do have hands-on responsibilities in individual files, so I educate. What I'd like to do today is because of the nature of the people that we have in attendance per our discussions with Peter, I'd like to educate and motivate and then call to action, because I understand that some of the companies that are attending, and I'm looking at the list, I think every one of them is a client to some extent. It's important that we as an industry protect the rights that we have because they're valuable, and for years we've taken them for granted. So with that, let me begin again. If you have any questions, if you can't hear me, if you'd like me to go over something different, give Jamie a call here at 262-673-7850 or email her at jbreen, J-B-R-E-E-N, at mwl-law.com. Or you can go into the interface and raise your hand, and Jamie's going to be monitoring the entire webinar and will respond. And she always comes in with questions and things and hands me little notes, so we'll do the best we can. Again, welcome. Matthiesen, Wickert Lehrer is a law firm located in Hartford, Wisconsin. That's not by chance. I grew up here in Wisconsin, but I cut my teeth and learned to practice law after I got out of law school in Houston, Texas, where I practiced for 20 years with Hughes, Waters, and Askenase. I started and headed up their subrogation department down there in the early 80s, at a time in which tort reform, the quote-unquote lawsuit crisis, and those political machinations of the insurance industry were in full swing. Trial lawyers were just beginning to feel their oats. They had seen successes after flexing their muscles during the 70s, and we'll talk about that in a little while. And we began representing insurers in all lines of subrogation, starting with auto and including workers' compensation, health, fidelity, property, casualty, fire, inland marine, cargo claims, Jones Act, longshore, just about anything that could put money back in the pockets of my clients, we did. And we began the first national subrogation program back in 1983, and that has expanded to 316 sets of local counsel we have contracted throughout North America and the world, subrogating in all 5 continents right now, the major continents. And so we've enjoyed some success, and it's not because we're smarter than anyone else, but as my dad always taught me, you may not be the smartest one in the room, but make sure you're the hardest working, and that we certainly are. Our advantage in subrogation, and particularly in workers' compensation subrogation, is knowledge. It is education. And I want to tell you a quick story. It happens to involve a Texan who was in New York City getting ready to go over to Europe for business and needed a loan, so he walked into a bank in Manhattan and told the loan officer that he was going to be in town for a few weeks before he traveled and needed to borrow $5,000, and that he was not a customer of that bank. Well, naturally, the bank officer looked at the Texan and said, well, I'm going to need some sort of security, something that we can hold so that we know we'll get our money back. So the Texan handed over the keys to a new Ferrari, which he had parked out in front of the bank. The banker checked everything out, and he agreed to hold the car as collateral and apologized for having to charge 12% interest. Later, the president and all its officers had a good laugh because at the Texan's expense, because he used a $250,000 Ferrari for a $5,000 loan. Well, the employee of the bank drove it into the bank's private heated underground parking garage, and 2 weeks later, the Texan returned, repaid the $5,000 along with interest of $23.07. The loan officer said, sir, we are very happy to have your business, and this transaction has worked out very nicely, but we're a little bit confused. We're puzzled. As part of our due diligence, we checked you out, and you've got a lot of real estate holdings. You're obviously a very successful person. Why in the world would you bother to borrow $5,000? And the Texan looked at him and said, well, where else in New York City can I park my car for 2 weeks for only $23.07 and expect it to be there when I return? That sort of ingenuity, that sort of using and gaming the system with knowledge is exactly the way that we have to be prepared to address and protect compensation subrogation. And what I'd like to do in the process of covering the things that Peter suggested we should cover, which I'm going to go over just briefly the history of work comp subro because I have a point to it. Then I'm going to talk about the exclusive remedy rule, the protection of the employer under the system we have in place and how it's been eroded in multiple states. Because we practice in every state, I'll have examples and opinions from every state. We're going to talk about subrogation challenges presented generally and specifically by employee leasing, temporary employment agencies across all 50 states. We're going to talk about some trends in workers' compensation subrogation. I'm going to do something I've been asked to do by Claims Magazine but have never done until today, and that is I'm going to rank the top 10 states in the country for workers' compensation subrogation the best, and I'm going to rank the worst 10 states, and I'll give you examples why. Some of the handouts that Jamie has forwarded to Peter, which you may have, and I apologize in advance that they're a little voluminous. There is a workers' compensation subrogation in construction settings in all 50 states, which I find valuable and will relate to the employee leasing and exclusive remedy discussions we have. There is a chart on employee leasing subrogation laws in all 50 states that gives a quick summary of the employee leasing laws in all 50 states and how it affects and interfaces with workers' compensation subrogation. There is a chart on workers' compensation subrogation in all 50 states, which is just a general quick reference chart. We have a book, which many of you may be familiar with, Workers' Compensation Subrogation in all 50 states. I won't peddle it. We don't make a lot of money on it, but and the only reason I mention it is because it does contain a lot of the answers to the questions that come up. For those of you who have questions in your handling of matters after today or at any time, we have a feature on our website where you can submit a subrogation question and you normally get an answer within an hour. One of our attorneys here, myself, or one of our attorneys around the continent will respond with an answer, state-specific, provided it's a general subrogation question. I can't look at cases and contracts and insurance policies and give coverage opinions. Obviously, that's what I do for a living, and besides that, it's really pretty foolish to practice law via email without having entire files to look at. But we do answer questions and answer them completely and are somewhat well known for doing that. So I'd like to now start and just give you a little bit of the history of workers' compensation subrogation. Trial lawyers are oh so proud to talk about their common law heritage and their 200 years of common law experience and the rights and the open courts doctrine and the rights of victims. Workers' compensation subrogation goes back, or workers' compensation, in fact, goes back quite farther than that. It goes back to the year 2050 BC, to the Nippur tablet number 3191 from ancient Sumer, which is now Iraq, And a few years later, in 1750 BC, the Code of Hammurabi provided monetary compensation for specific injuries and their resulting permanent impairments. The ancient Greeks, the Romans, the Arabs, the Chinese all provided programs of compensation with precise scheduled payments for specific injuries. My son is a third-year law student at Marquette. He's a research law clerk here, and he happens to be working on a book with me on insurance coverage fundamentals, which will be out later this year. And I had no idea. I think Jamie found this photograph, which is going to allude to the workers' compensation system set up, a complex system set up by pirates in the 17th and 18th centuries. And it turns out my son walked in my office with a chart he was working on and looked at it and said, "Hey, Dad, that's from Assassin's Creed," which I guess is the new hot video game out there. But who knew that pirates were highly organized and entrepreneurial, and their activities and their vocation involved sea battles and sword fights, swinging from ship to ship on rigging, and cannonballs whizzing past. Anybody who's seen the series Black Sails, which is just awesome, gets an idea for their average workday. Well, obviously this is a high occupational risk job, and Captain Henry Morgan, who in the mid-1600s drew up a ship's constitution that provided for quote-unquote recompense and reward each one ought to have that is either wounded or maimed in his body, suffering the loss of any limb by that voyage, close quote. And so when plunders were taken and booties were absconded with, pirates who were injured were given 100 pieces of 8, which is essentially a Spanish dollar for the loss of an eye, 500 pieces of 8 for the loss of a left arm, 600 pieces of 8 for the loss of a right arm, et cetera, et cetera. So the system of workers' compensation was well developed even back then. We moved to 1875, and we find that back in ancient Prussia, I say ancient, in 19th century Prussia, Chancellor Otto von Bismarck, although no humanitarian, was a brilliant politician and knew that he had to get the people on his side. And the politically activist socialists at the time were a considerable thorn in his side, so he co-opted features of the socialist agenda, beginning with the Employers' Liability Law of 1871 that provided protection to workers in certain areas like factories and quarries and mines and things like that, railroads. And then just a few years later, in 1884, Bismarck pushed through the far more significant workers' accident insurance, period. That's the name of the legislation. And that created the first modern system of workers' compensation known to man. If a worker was injured on the job, he received medical care and rehab. And even more important, and here's where we begin our exclusive remedy discussion, back in Prussia, the compensation system announced that workers' compensation was the exclusive remedy for employees who could no longer sue their employers in Prussian civil courts. Turning to England, just a few years later, it was Prime Minister William Gladstone back then pushed through the Employers' Liability Act, and this abolished the old common law defenses that employers could use to defend suits by employees against their employers. But it far fell short of being a no-fault system, and it wasn't until 1893 when the quote-unquote Workers' Compensation Act was first proposed and passed, and it was almost identical to the Prussian system, although the English model relied on something called friendly societies instead of the government to administer the program, so it wasn't quite as effective because people could opt out. And but this passed and was a major predecessor, of course, to the common law, which our forefathers brought over to our shores, and which we see in America at the beginning of the 20th century. In the early 1900s, the winds of change were a little bit slower, but U.S. public sentiment was decidedly against a system of workers' compensation until the proliferation of the Industrial Revolution, until Upton Sinclair wrote his book, The Jungle, until we had the Triangle Shirtwaist Fire, and there was a lot of outroar and outrage about employees and work conditions and child labor. And coincidentally, politically, for those of you who are political historians, the socialist movement was in full swing back at this time. Employers in America were growing tired of suits by employees who would lose limbs or get hurt or herniate discs while working. And the three common defenses that were used at the time were contributory negligence. And I remember this because this is going to play into our analysis of states today. Pure contributory negligence. If the employee is 1% at fault, he cannot sue. This was a defense that was made available and made winning almost impossible for employees, so they weren't happy either. The fellow servant doctrine was the second common law defense. Employees weren't responsible if the injury resulted from the action or negligence of a fellow employee. And the assumption of risk was the third of the so-called unholy trinity of defenses that were available to employers at the turn of the, 2 centuries ago, I guess, in the early 1900s. And the assumption of the risk defense said employees who knew of hazards when they signed their contracts agreed to that inherent risk. So this made winning by the employees very difficult, but suits followed nonetheless, and employers were tired of defending them. So employers and the labor, which just began to grow at the time, began to consider workers' compensation, which was first enacted in 1908 to cover federal employees who were engaged in hazardous work, and in 1916 the rest of the federal workforce was covered. As far as state workers' compensation acts are concerned, and work comp is exclusively a state phenomenon. There were failed efforts in New York in 1898, in Maryland, in Massachusetts, and Montana. They all failed. But in 1911, the stars were aligned in Wisconsin. Victor Berger had just become the first, I think he was elected to Congress. He was a socialist. We had a mayor here, Mayor Emile Seidel, who was the first socialist mayor. We'd been the first state to enact work laws and work hour prohibitions and child labor prohibitions. We created vocational school systems. So it was only right that Wisconsin become the first system to pass a work comp law, and that's what happened in 1911. So in 1911, the first Workers' Compensation Act was passed that withstood constitutional scrutiny, and this became a huge compromise in America. And this is something that we must remember, and the whole reason for this short history lesson, which may be a little bit hokey, is because we need to remember that this system of workers' compensation, which spread from Wisconsin to all the other states, was a huge social compromise. And nobody, not employers, not employees, not doctors, healthcare, no one was completely happy with it. It was known as the great trade-off back then because both labor and industry had to be willing to give up something for it. Employers gave up, employees rather, gave up the right to sue their employer. And no longer could employees just sue their employer for negligence. In fact, employers enjoyed complete immunity from suit. And in exchange, employers were now on the hook in what is really a very strange anomaly in U.S. jurisprudence. Employers were now on the hook for unlimited benefits, indemnity, medical, millions of dollars in benefits in the event of a catastrophic loss, quadriplegia, paraplegia, even death. We had significant losses that an employer, through no fault of its own, Mom and Pa's pet shop, is now on the hook for millions of dollars in medical through no fault of their own. It's a very un-American system. It's a system with very socialist taints. It's a square peg that doesn't fit into the round hole of the rest of U.S. jurisprudence, which is why it's important to remember that there was a trade-off. The employers traded their immunity from having to pay medical unless they were negligent. In other words, it was now they were liable simply if the accident happened in the course and scope of employment and the employees gave up the right to sue the employer. Unfortunately, as we'll see as we talk about exclusive remedy, we've forgotten one half of that trade-off. Trial lawyer lobbies, and we'll talk a lot about them, have eroded the system of exclusive remedy, which was originally the premise of this great trade-off, this great social compromise. And when I speak to legislatures around the country, sadly, all the proponents of some tort reform or some act which harms subrogation or amends workers' compensation so that the employer can be sued, or limits the recovery by the workers' compensation carrier. I'm always the one on the right side. Sometimes I'm the only person sitting on the right side of the room, and all the proponents of the bill are packed on the left side. It's a little disconcerting because our industry has historically, and that means everybody listening, your companies have historically not given subrogation its deference. It is a strange bedfellow. Strange because as insurance professionals, we're conservative politically when it comes to litigation and the American civil justice system. We have traditionally been in favor of tort reform, which is good. However, we have simply forgotten subrogation, and I have examples later about how insurance companies, Republicans in Congress, Republicans in state legislatures, including friends of mine here in the Wisconsin legislature, end up being the biggest proponents of harming subrogation, thinking they are somehow helping the state. And so we'll talk a little bit later about some of the societal benefits of subrogation and why it's important. So with regard to subrogation, we're talking about 1911. Wisconsin has passed this Workers' Compensation Act. Employers can no longer be sued by their employees. In exchange, they have to pay unlimited sums of money through no fault of their own due to a clumsy, careless, and sometimes reckless employee. And what happened for a few years was that the work comp system was working. Employers were paying out benefits. And by the way, many of you who are familiar with the history of your companies will recognize that your companies began in 1913, 1916, because these were where the associations were started, where employers needed coverage, and many of your entities had their starts with workers' compensation back at the turn of the 20th century. So everything was working well, and employees were no longer able to sue their employers, which made the employers happy. The employers had to pay medical, which didn't make them happy, but they enjoyed the trade-off. Insurance was covering the losses. All they were paying were the premiums, and insurance stood in the middle. Well, what was happening is plaintiffs were, in addition to recovering their benefits, allowed to sue a third party, some tortfeasor who was responsible for the loss, and they would sue the third party and make a recovery and then also recover their benefits and end up with a double recovery. And this was disconcerting, and finally, around 1917 to 1920, most of the states began enacting subrogation provisions. And today, every state has a provision statutorily with regard to workers' compensation subrogation, and that's about where the similarity ends. The chart I gave you with the workers' comp subro laws of all 50 states will show that there's a great variety of approaches, ideologies, and states which are run by a lot of the trial lawyer lobbies will see more harmful laws in there which protect injured employees and forget the trade-off and the social bargain we made. And some of the more conservative states will have more favorable subrogation. And one of the things we have to do is recognize those states. And of course, I'll have the top 10 and the bottom 10 toward the end of this webinar. So subrogation grew around those 1917 to 1920, and the purpose of this was, number one, to place the loss ultimately on the wrongdoer and to prevent a double recovery. These are two fundamental concepts of insurance and two fundamental concepts of equitable insurance, i.e., equitable subrogation. Equitable subrogation is subrogation via common law. You don't have to have a clause in your policy, a reimbursement language in the work comp policy. It's it's something that accrues as a matter of common law. But we're not talking about equitable subrogation when it comes to workers' compensation, and that's something a lot of judges and legislatures have forgotten as they attempt to morph us and harm subrogation over the years. We are dealing with statutory subrogation, and every state has a statute which provides that the work comp carrier is entitled to recover its money. And so my job and your job is to recover that money wherever possible. It's not a simple job, and it is more complex and is complicated due to a lot of reasons, including roles that the employer plays. I mean, our insureds are significant clients of ours. We want them to be happy, but we want them also to understand that subrogation helps to reduce insurance premiums. It helps keep the experience mods low. It helps small businesses, and that's a major factor of subrogation that has not been driven home, has not been documented, is not given sort of the attention and respect that is needed in order for that to become a factor in public policy making. And one of the other advantages of subrogation is that it actually reduces the number of lawsuits. This is a fringe benefit, but if you think about this, workers' compensation, subrogation actually, and subrogation in general, actually makes some of the smaller cases less attractive to plaintiffs' attorneys because of the liens, because of the obligations for reimbursement. And so let's talk about some of these in general. Let's talk just briefly about the effect of insurance on subrogation, because trial lawyers will adamantly disagree with you that it's not done, and if there is benefit to the insurer does not pass on that benefit. One legal scholar at the University of Chicago explained how subrogation impacts insurance premiums, and he said, quote, "An insurance company sets its rates based on historical net costs. Thus, if the insurer has 100 policyholders in an experience period and experiences a total of $20,000 in claim costs, it will set an actuarial premium at $200 per policyholder. But if, on the other hand, the insurance company experiences $20,000 in claim costs and receives $5,000 in subrogation, it will set its actuarial premiums at $150 per policyholder. So the revenue gained by the insurer through subrogation is applied toward responding to the actual risk. We need to do a better job of documenting that." Courts throughout the country have agreed that subrogation assists society by lowering insurance costs, lowering premiums, helping small businesses, and reducing and eliminating, in some cases, double recoveries. So by allowing subrogation clauses in contracts, by giving consumers have actually a greater choice as well as reduced premium. Now, the correct measurement and assessment of the loss potential in any insurance underwriting function is the very foundation of our system of insurance. And this assessment is accomplished only through the careful analysis of our insured's history, their experience with loss, cost of administration of insurance, the application of probability and mathematics of chance, as well as the likelihood that any loss will be recouped through subrogation. It's an important underwriting function that most of our underwriting departments who are on autopilot and have been for 3 decades often forget. Waivers of subrogation are sold for $350. Clauses are put in contracts with regard to mutual waivers of subrogation. Endorsements are put in policies without much forethought, without much consideration of the fact that you could be waiving millions of dollars, and we see it every day. Almost every day I see a huge catastrophic loss case in which there is some sort of waiver or serious compromise of subrogation rights, and that's unfortunate, and it's often unforeseen. and then the file is closed and nothing is really done. When I mentioned subrogation reducing the number of lawsuits, think about it as a form of tort reform. Insurers filing subrogation actions will not increase the number of lawsuits. I have a good friend who's in the Wisconsin legislature, and there's a bill pending right now. And I've called him several times, and I've said, harming subrogation isn't going to reduce the number of lawsuits. It's going to increase it. And I have a hard time getting that point across, because trial lawyers are going to look at and most of the claims are smaller claims. Let's agree to that. And then in these smaller claims, if you've got a $10,000 PIP, MedPay, comp lien, and not much in the way of non-economic damages, trial lawyers are going to look at that and go, I'm sorry, sir, but I'm not going to take this case. And then the responsibility for recovering it falls to us, to you and I. And that's the way the system was meant to work. Oftentimes the busybody, the intruder, is the trial lawyer who takes a case he never should take and ends up whining about, well, his client doesn't get any money after he takes a third of the fee. So subrogation has the effect of reducing lawsuits, especially the smaller ones, which are filed in great numbers. So we've talked about what subrogation is and why it's important. So now let's discuss today's challenges in terms of the exclusive remedy rule and employee leasing and temporary employment agencies. If you think back to the compromise that we talked about, the social compromise in the early 1900s, the deal was a couple who owned a pet shop could be responsible for $1 million in medical expenses that they did not cause. Now, in America, that seems just unconscionable. But of course, the compromise was that, well, in exchange, you cannot be sued. So if you happen to cause that injury by having inadequate equipment, poor training, premises liability considerations, et cetera, poor maintenance on a company truck that is used and the brakes fail, you can no longer be sued. So you have the potential for protection too. But in the long run, the exclusive remedy rule was supposed to be the heart and soul of the bargain for the 105-year-old workers' compensation system we have. Unfortunately, while the no-fault end of the trade-off, the employer's liability for benefits, has remained unchanged, legislatures and particularly the courts have continued to chip away at the exclusive remedy doctrine. The exclusive remedy defense, by the way, is not limited to suits filed by employees, as we've discussed, but if the employee sues a third party, a tortfeasor who causes the injury, that third party has the right to bring in as a third party defendant any other tortfeasors it thinks contributed to the loss, and quite frequently, most frequently, that target which enters their sights is the employer. So the exclusive remedy defense is meant to protect both the employer from suits by the employee and from third-party contribution actions from tortfeasors who have this right of contribution when they are sued by the employee. A couple of comments before we start talking about the erosion of the exclusive remedy rule. Coverage, which is, and this becomes fascinating and becomes part of the mosaic that we have, part of the maze that we have to find our way through when working through these workers' compensation claims. And think back to the story I told at the beginning of the webinar, the Texan who goes into the bank. This is the kind of mindset we have to have, armed with knowledge, armed with a superior grasp of work comp law and many of the exceptions. We have to be aggressive in protecting these rights and protecting the exclusive remedy rule and our right of subrogation. But as far as coverage is concerned, on your comp policy, Part 1, Coverage A, covers the benefits you're required to pay under comp law, and there's normally no limit to this. Part 2, of course, Coverage B, insures an employer for obligations to pay damages because of bodily injury, including death, if the condition arises out of or in the course of employment, and there is a legal remedy theory available to the employee beyond the comp statutes. And that could be any number of things. But when you have contractual indemnity, this is known as third-party over liability, where a defendant sued by the employee, someone other than the employer, has a contract with the employer. And we see this time and time again, where the poor subcontractor or the little man in the transaction has no choice but to accept the 0.6 font on the back of a bill of lading or in a contract or in an AIA construction contract, which provides that they will indemnify the third-party tortfeasor. Well, then you have another source of liability against the employer, one based on contract. And contractual indemnity is allowed in most states, whereby if the employer contracts to indemnify a third-party tortfeasor, that tortfeasor can bring the employer in, and we often have difficult decisions to make then as the subrogating comp carrier. Okay, the employer is IBM, the employer is Walmart. Do we want to piss them off by subrogating and recovering our money, notwithstanding the fact that they're going to be holding the bag at the end of the day? These are considerations that have to be taken into account, both from underwriting on to the conclusion of subrogation. But the exclusive remedy rule, of course, employee is barred from tort action against the employer and co-employees. And by the way, this is a good time to mention, we're talking about not a set of statutes, not a body of law that we can pull up and I can put on the screen in front of you. Remember that one of the subrogation challenges for all of us is the fact that we are dealing with 51 different bodies of law, 50 including DC, 52 if you consider federal comp, the Overseas Bases Act, Longshore, Federal Employees Act, FELA, and all of that. I mean, you're talking about a lot of law, and it's very, very difficult to be familiar with everything. As difficult as it is for me to express a golden rule to you, because there are always exceptions. That's the reason for the charts and the handouts that I've given you. I want you to realize that every state is a little bit different, but generally, of course, exclusive remedy bars the employee from a tort action against the employer or co-employees. The rationale, the public policy we've discussed. It's part of the social trade-off. There are exceptions. Let's talk about those exceptions. Contractual indemnity we just discussed. Intentional acts and gross negligence. Intentional acts and gross negligence are a growing and abused exception to the exclusive remedy rule. Where permitted under state law, an employee may have a cause of action beyond a work comp claim when an employee is injured at work and files suit against an employer alleging an intentional act, i.e., a willful physical assault of some nature. These types of cases involve a common law cause of action for damages, and as a practical matter, they're defended under Part 2, Part B coverage, because it's usually a question of fact as to whether or not the injury was intentional or not. And until that's decided, the coverage comes into play. But in many jurisdictions, the concept of what constitutes an intentional act has been expanded beyond simply a deliberate intent to injure. It's been expanded to include injuries that result from, say, willful indifference of the employer. For the rest of the seminar, I'm going to be giving examples in different states. I apologize that there's 50 states and I can't hit them all. There's two things you can always resort to. Number one is our book, and I'm happy to, Peter, I'm happy to send a copy of the book for AIA, a complimentary copy. Like I said, we don't make much money on them, but I do take great pride in the fact that we keep them current, and they are quite detailed. But it's important to, when I go through these states, I'm going to give you examples. It doesn't cover all 50 states, but with regard to intentional acts, Alabama, for example, Alabama's intentional act exception to the exclusive remedy rule applies only to supervisory employees, what they do. In Alaska, if an employee violates a safety standard, it's considered an intentional act whether it was or wasn't intentional. Intentional exceptions to the exclusive remedy rule exist in Arkansas, in Connecticut, Florida. In Idaho, it's unclear. They exist in Indiana, but in Indiana, the employer itself must harbor deliberate intent. And it doesn't have to merely be a supervisor, manager, or foreman. It can be anybody working who could provide this deliberate intent on behalf of the employer, to allow for the exception to the exclusive remedy rule. Kansas, Kentucky, Maryland, Mississippi, Michigan, Minnesota all have intentional injury exceptions. Maine, the remedy applies even if the intentional act leads to the death of an employee. Some states have a higher bar. New Jersey, for example, requires substantial certainty of harm. Some states have a lower bar. Iowa, for example, allows just mere gross negligence to constitute an intentional exception to the exclusive remedy rule. So as we think about exceptions in the erosion of exclusive remedy, we've now accepted not just intentional acts, gross negligent acts, but acts which were merely negligent, which happen to violate some sort of safety rule or regulation. So we have a significant chink taken out of the armor of exclusive remedy, and it's just one example of many of how the exclusive remedy protection has been and is being eroded. Dual capacity. Employers who have this protection may lose that protection if they wear a hat other than that of employer. Let's say they are also, the employer, in addition to employing an employee, also supplies a product which injures the employee. They provide a service. They provide health care. It could be a hospital, for example, where the employee is treated at his own employer for some sort of injury. They could be the owner of the premises other than the workplace. So when a work-related injury arises out of one of these secondary relationships, these dual capacities, these second hats that the employers wear, then the exclusive remedy rule as a source of recovery can be challenged. For example, and I had a case recently where an employee of a forklift manufacturer out on the West Coast in Oregon was using a forklift made by his employer to move around goods in the warehouse. Well, the forklift malfunctioned. It resulted in an injury to the employee, and the employee filed a work comp claim and also sued his employer under a products liability theory. And the defense attorney, of course, filed a motion for summary judgment. Well, you can't sue us, we're the employer. Well, unfortunately, you're two things. You're the employer and you're also the manufacturer. So in that state, dual capacity allowed the employee to maintain both the Work Comp Act and a lawsuit for the product defect. This is known as dual capacity. Other states call it, Wisconsin, for example, calls it dual persona. Excuse me, just to be different. One second. My apologies, I'm getting over something and I had to get a glass of water. So dual capacity takes another chink out of the armor of exclusive remedy. In Texas, there's an exception for gross negligence in a death case. Now, let's think about that for a moment. I practiced law for 20 years in Texas. When this became law, I was asked to testify before the legislature, and it really makes no sense. We have a deal. Our employers are supposed to be immune. In turn, they can be liable for unlimited amounts of medical. What happened to the deal when trial lawyers said, well, but if there's gross negligence and there's a death, it's really not fair that the poor, injured employee or his family should be without a remedy. And then when you get enough ex-trial lawyers on the legislature or on the legislative committees, you have people who listen, and somehow this sort of argument gets traction. So it's often the rich, the rich insurance company is the one who ends up holding the bag, and we're the ones who get dinged on, while the injured victims are the ones whose rights are expanded. Exclusive remedy is also, and this is significant, attacked and reduced in a growing number of states. And if I had to put on a hierarchy of some of the growing challenges to work comp subrogation's exclusive remedy rule. This is going to be right up there with them, second possibly only to the made whole doctrine, which we'll talk about in a second. But the evolution of comparative fault has infected the work comp system, and it's infected the exclusive remedy protection at the same time. Think back historically, pure contributory negligence was common law. If a plaintiff is 1% at fault, he or she is barred from making a recovery against the tortfeasor, and that's the end of the story. Well, of course, this wasn't fair, and the 4 states that still maintain pure contrib, there's a lot of pressure to reform in the United States now, but most states have some form of comparative fault. By the way, there's a comparative fault contributory negligence chart on our website, along with dozens and dozens of other charts for you. A great place to go for resources and reference. And that chart details the contrib, comparative fault laws, the 50, 51% bar rules for each state. But with regard to the exclusive remedy rule, the evolution of comparative fault, in other words, plaintiff might have been 20% at fault, but we're not going to bar him or her from recovery. We're just going to say that, well, then he or she can only recover 80% of the damages. We're going to reduce by 20% relative to the fault of the plaintiff. This ability to split the baby woke up judges and lawmakers and trial lawyers to a creative argument that, hey, employers should be treated the same way. If an employer was at fault in causing the injury, even to a small degree, the plaintiff shouldn't be allowed to recover. And in fact, there are situations where I consider myself a trial lawyer for the insurance industry. That's how we're successful, by aggressively going out there, being creative in looking at, investigating, documenting, and pursuing third-party liability under existing tort civil laws. And I belong to, and I don't often admit this to my client, but since 1984, I've been a member of the American Association for Justice, the AAJ, formerly known as ATLA, Association of Trial Lawyers of America, which is the preeminent trial lawyers organization. I write for their magazine. I am on their listserv, and the reason for that is because I am a plaintiff. When you hire me, I'm a trial lawyer filing suit as a plaintiff, or I'm assisting a plaintiff. I am out there to recover subrogation dollars, and I have to creatively accomplish that for my client. Comparative fault laws came about as a result of trial lawyers' lobbies, and when an employer was at fault, at least to a small degree, there were 2 possible solutions. One was to have its lien reduced proportionately, or the other was to bar it altogether from making a subrogation recovery. And as you can see, the carrier's subrogation is reduced by state law if the employer is negligent, even to a small degree, in Alaska, Idaho, Kansas, Louisiana, New Mexico, and a state which has, over the last few years, dropped out of the top 10 in favorable work comp subrogation status, Texas, mainly because of tort reform over the previous decade, which has made it much more difficult for subrogating carriers and much easier for injured employees. In Arizona, you can have a comparative fault reduction of the employer's lien if there's a verdict. In New York, you can have the same result if there's a grave injury. In Utah, they have just out of thin air picked the 40% rule. If the employer's negligence accounts for 40% or more of the loss, then you are barred from making a recovery. And you can imagine that makes for some creative and challenging work comp subrogation scenarios that we have to deal with. In Alabama, removal of machine guards eliminates the employer's lien. Again, that may be well-intentioned. Guards shouldn't be removed. Employers shouldn't make mistakes. but we're forgetting about the fact that when the employee makes a mistake, the employer is still on the hook for literally unlimited amounts of money. We're forgetting the social bargain in Alabama. Common law contribution. Common law contribution is allowed in Illinois, Kentucky, Minnesota, and North Carolina. And of those, the two most traditional types of common law contribution the employer is allowed, the third-party tortfeasor is allowed against the employer are in the states of Illinois and Minnesota. Illinois copied Minnesota's laws, but Illinois is the classic state where work comp subrogation has become a big problem and can actually lead to employers paying fresh money. Now, flashback to 1911, the social bargain that we made, the purposes for the exclusive remedy rule, but Illinois is run by, and so we have a state where the only people who are being listened to are the trial lawyers, and the trial lawyers lobby, and they now have a situation where for many years, from 1913 until 1978 in Illinois, not only did the employer enjoy liability from direct suit, but it was also protected from third-party contribution actions. This ended in 1978 with the case of Skinner versus Reed Prentice, and in that case, the Supreme Court held that a manufacturer sued in a strict tort liability action had a right of contribution against the employer. And the rationale was, it's not fair that the party has to pay all the damages when the employer is partly at fault. And this was fine because what happened was in Illinois they limited, and as many of you are familiar, they limited the contribution under the Kentucky case, which was a Supreme Court case in 1991, they limited the contribution amount to the amount of the lien. Well, that seems fair. If you're going to have contribution, which we shouldn't with the social compromise, you should at least limit it to, as Kentucky did, the amount of the lien. Well, unfortunately, case law has further progressed, and if the Kentucky cap, as it is known as, is waived by contract, then the employer can be liable for unlimited amounts of money as a result of simply initialing an invoice that had indemnity language on the back. This was not the intent of the social compromise, and it is not a fair bargain given the history that we went through with workers' compensation. And as we know in Illinois, just about every contract contains a lot of this indemnity and waiver language as a matter of course, without the parties even knowing or understanding why it's in there, which is something else that underwriting really has to approach with a lot of its insureds. Anti-indemnity laws in a lot of the states, there's a chart that we have on the website covering all of those, are a small move forward, but in Illinois you have a serious problem where employers can be liable for fresh money. And that puts a whole new twist on subrogation, and that makes doing business in Illinois much more expensive. In other states, such as Tennessee, employer negligence is allowed as evidence, but that's about it. So we can see that employer liability exclusive remedy rule has been breached. And that's unfortunate, and it should be reflected in the premiums that employers pay in states where they've decided to side with the trial lawyers instead of the insurance industry. Employee leasing and staffing. This is another issue that has complicated workers' compensation subrogation and brings about an important point, and that is public policy has been moving at the speed of light to keep up with industry, to keep up with trends, to keep up with the economy, to keep up with novations of contracting and business practices in our society. One of these practices, of course, is a situation where an employee is leased to another employee. Now, we all know about the borrowed servant doctrine. You can't deal with work comp without understanding borrowed servant employee. employer A's employee goes over and does a task for employer B, and while he's under the direction, supervision, and control of employer B is actually his employer and can enjoy the benefits of exclusive remedy. So sharing exclusive remedy through the employee leasing and temporary employment phenomenon that is going on in the country and is proliferating is particularly troubling, because what companies are doing is they're making employers immune, even the special employers. For example, with the advent of employee leasing and temporary employment agencies and staff leasing services, virtually every state has enacted legislation in construction settings or in employee leasing settings requiring contractors to pick up the provisions of work comp coverage and make the borrowed employees statutory employees of the general contractor. In temporary employment situations, you have a situation where states have enacted statutes which simply say both the client of the employee leasing company and the employee leasing company themselves are going to be considered statutory employers of the employee, and as a result, we're going to give them protection under the exclusive remedy rule. Both the leasing company and the client company are deemed employers worthy of the work comp exclusive remedy bar. Texas enacted the Temporary Common Worker Employers Act in 1991. This covered temporary employment services that loan employees for short periods of time, or in some cases a day, a single day, or a single task even. The Temporary Common Workers Employers Act in Texas, unlike the sister Staff Leasing Services Act in Texas, doesn't specifically provide for dual employment, but the law of each state does deal with that. And for example, each state varies its application of the exclusive remedy rule to situations involving employee leasing. And the underlying issue in all of these cases is, can the employee injured while working for the special employer sue the special employer or the general employer, or neither? And right now, 33 states have statutes, regulations which deal with this, and 17 have state court decisions which deal with it. The handout I've given you, Employee Leasing 50-State Chart, sort of summarizes the law in each state, so we don't have to go through those. But that's a reference that is important for you to realize that that is a big obstacle. Another obstacle and an erosion of the workers' compensation subrogation right that we have in the social compact we made is the made-whole doctrine. States vary differently on how they approach this. Most of you realize that and are aware that in insurance subrogation, when the insured is not made whole from a third-party recovery, and the subrogated carrier and the insured are vying or contesting over a limited pool of funds, quite often policy limits, equitable law, which is what the made-whole doctrine is, and it applies to equitable subrogation, which is subrogation without a contract, subrogation without a statute giving it, subrogation rights. The made-whole doctrine provides that the insured must go without, the insurer must go without its subrogation recovery, and it can't subrogate until the employee is made whole. Unfortunately, and this is a whole nother topic, but most states have started mingling and conflating equitable subrogation with contractual subrogation. Some states still say, hey, you can contract around this. The policy is the policy. In the United States, under the 10th Amendment and under the U.S. Constitution, two parties can contract with one another, and they have that right to do so. But in other states, they've said, well, I don't care what the contract says. We're not going to allow you to contract to avoid the made-whole doctrine. With regard to workers' compensation, however, it's even more troubling because we have this social compact. Nobody said that under workers' compensation in America the employee could only recover benefits provided the employer had the ability to pay. Nobody said when we enacted our work comp statutes that you know, the employer might not be fair for the employer to have to pay all those medical bills, even though it had nothing to do with causing the injury. Yet on the other side of the coin, judges and legislatures are saying, well, it's not quite fair that the employer and its work comp carrier recover subrogation dollars if A, the injured employee isn't made whole, or B, there's some other equitable reason. And we see this exhibited in states like Georgia, where, as you'll see when we get to the list of states, it is the worst state for workers' compensation subrogation. They've codified the made whole doctrine, and is the only state to do this, into its workers' compensation subrogation statute. And in Georgia, the carrier can recover its subrogation dollars only if the employee has been, quote unquote, fully and completely compensated, taking into consideration both the benefits received under this chapter and the amount of the recovery in the third-party claim for all economic and non-economic losses. Georgia also throws some other obstacles in our way, which we'll talk about in a minute. So if an employee in Georgia is made whole, then and only then can the carrier recover limited subrogation rights, and those rights are limited to damages which represent economic damages in Georgia, so there's a double whammy there. Other states provide an apportionment formula. When the employee claims it's not made whole, then the employee can go to the court, often a prior trial lawyer, sympathetic to the fact that the insurance company has more money than the injured dock worker or warehouseman. And states like Arkansas, for example, apply something known as the Franklin formula. In Arkansas, the carrier's right to subrogation arises only in situations where the recovery by the insured exceeds his or her total amount of damages incurred. And they apply the made whole doctrine rather broadly. And the Franklin formula says that the precise measure of the carrier's reimbursement is the amount by which the amount by which the sum received by the insured from the third party, together with insurance proceeds, exceeds the loss sustained and the expense incurred. So you see what they're doing with the Franklin formula in Arkansas is they're saying, well, that's great, Liberty Mutual or Travelers or Zurich. I understand you've paid all these benefits, and I understand there's a third party out there guilty as hell, and I understand we have this deal, wink, wink, whereby you know, you're going to pay benefits, you're going to be protected from third-party suits, and you're going to be entitled to recover in exchange for being liable for all these medical expenses. But in Arkansas, they've literally decided that we're going to make sure the employee is taken care of first and the employee's attorney is taken care of first with costs, fees, expenses, before we let the carrier recover $1. That's a major breach of the social compact, and it's a major breach of workers' compensation subrogation rights. We moved to Florida, where the Manfredo formula, and I love these formulas, they sound so dignified. In Florida, where, by the way, they don't allow you to intervene. You have a significant property right, millions of dollars in damages owned by, a right owned by the workers' compensation carrier. And Florida courts have decided, well, we don't want the meddling work comp carrier to muck up the trial lawyer's strategic and well-thought-out plan in his litigation, so we're going to allow you to file only a notice of lien. And if and when there's a recovery over which you have no say, by the way, the third-party settlement, you're going to, under the Manfredo formula, you're going to recover the third-party settlement less attorney's fees and costs divided by the full case value, and that's the percentage of the lien you'll recover. And guess what happens when this formula comes into play? Trial lawyers bring other trial lawyers into the courtroom, and they get on the stand and say, yes, I understand there's $12,000 in medical here, but I think the case is worth $6.8 million. And the judge goes, okay, that sounds like a learned opinion, and you recover literally pennies on your work comp lien dollar. Kansas, the Brabander formula. Formula with diminished lien equals the lien minus damages times the % of the employer's fault. So here we have a combination of made whole and exclusive remedy taking down a work comp lien that was statutorily meant to be in place for us. These are court-ordered formulas. Missouri, the Rudiger formula. We see the growth. Formulas are not bad. Wisconsin, which I rank, as you'll see later, as one of the top states for work comp subrogation, has a formula, and that formula makes sure that costs and fees are paid to the trial lawyer, but it also makes sure that the work comp carrier recovers 100% of its comp lien. The Rudiger formula doesn't do that, and after expenses and fees are deducted from a third-party recovery, the balance is apportioned in the same ratio that the amount paid by the employer at the time of the third-party recovery bears to the total amount recovered from the third party. So it's a complicated formula that simply results in a reduced lien. There's case law made whole rules in Kentucky, Montana, New Mexico. Indiana has a strange creature. It's a lien reduction statute, which was never, ever meant by the legislature to apply to work comp, because of course work comp is a statutory right of subrogation. By the way, in Wisconsin there's case law that says work comp is not subrogation. Work comp subrogation isn't subrogation. It's a misnomer. Work comp subrogation is a statutory right of reimbursement that must be followed, period, end of story. Unfortunately, most states don't do that. In Indiana, via case law, extended a lien reduction statute which allowed a lien to be reduced when there wasn't enough money to go around, simply by edict of the court. There's other states that have limitations based on percentages. Certain percentages of recoveries can be made. By the way, all of these can be seen in the work comp subro chart, and there are other mechanisms in some other states. Other subrogation limitations that we have include damage limitations. The trial lawyers are hard at work, and they're very creative, and they are more motivated than we are, and they apparently want to protect their rights of recovery more than we want to protect ours. And the results are self-evident. In some states, there's a growing movement toward allocating between economic and non-economic damages. States like Louisiana, which limit carriers to 50% of their lien. Excuse me? 50% of the lien, it's arbitrary. Well, we think they'll be happy with half. Besides, they have a lot of money, so they don't need it. What they don't realize, and what we haven't done a good job of educating them on, is the fact that the other 50%, which we don't recover, is borne by the small employers. It's borne by the small rough carpenter out there who has to pay extra in his or her work comp premiums as a result of this stupid rule. And it does hurt small business in states like Louisiana that have an arbitrary rule like that. Governmental liability. Oh, but by the way, I know it sounds like we're rushing through a lot of this, and you have my apologies. There are a lot of webinars that we have online that you can go and view. You can view it right after this one if you want. You can go into our website and view dozens of webinars on work comp subrogation dealing with any of these issues in particular. For example, employer contribution, work comp subro. We went over that rather quickly. There's an entire hour-and-a-half long webinar on just that topic. I have an hour-long presentation on Illinois work comp subrogation and employer contribution in that state alone. So there's dozens of webinars that are recorded, and you can play free of charge simply by going on the website. So when I rush over some of these, it's a function of time, but some of these can be, if you have an interest, viewed directly from our website. Governmental liability. States like New Jersey simply decide we're going to put not only employees and trial lawyers ahead of subrogated carriers, but we're going to put the government ahead as well, because after all, those are our tax dollars. So states like New Jersey ban subrogation when a government entity is involved, subordinating subrogation to the taxpayer. Medical malpractice. If you look at the chart on work comp subrogation, you'll see that states approach the subject of subrogating against medical malpractice in a variety of ways. Where you have an injured employee and the injury is minor and the reserves are low, and he goes in and the doctor operates on the wrong leg and suddenly, or nicks the spinal nerve, you suddenly have catastrophic loss, high reserves, all as a result of the doctor's negligence. We, again, are subordinated to the interests of doctors because, of course, doctors are humanitarians, they're treating people, they're honorable, whereas the insurance industry apparently isn't. And 38 states, when you subrogate in a med mal case, and it's one of our specialties, we take cases and we look at the medical negligence, we have nurses on staff, they review the records, we hire doctors, we get them to point out the negligence, and then we make recommendations to the subrogated work comp carrier as to when they can recover. Of course, you can recover only those damages which flow from the medical negligence. Any amounts that you would have paid for the original injury in course and scope, which weren't the fault of the doctor, up to the malpractice, which could be the surgery, it could be over prescribing of medication, what have you. Only the amounts which were caused by the medical negligence can be recovered. But 38 states allow you, the comp carrier, to subrogate against a medical malpractice verdict. That means, depending on the state, as we'll see on the last bullet point here, some of us can't file in certain states. But depending on the state, you may be able to recover in 38 states. 8 or 9 states are undecided, and only a handful of states say no. California is one that says no. Legal malpractice. Your employee has a cause of action against the vehicle which rear-ended him or her, and she hires a lawyer, and you're waiting to see if that lawyer is going to file suit, and the lawyer forgets to file suit, and now both you and the employee, depending on the state, because in many states we can file even after the statute runs, and that, of course, is set forth in that chart as well. But if the lawyer malpractices, strange phenomenon here, and I'll leave it to your imagination to figure out why, but 13 states say no, we can't subrogate to legal malpractice because the attorney, quote unquote, didn't owe us a duty. 7 states say yes, and guess what? Most states are still undecided. When we're in the year 2016 and we have states which are undecided on significant issues involving millions of dollars for us, the insurance industry, you have to wonder why. How can that possibly be that this case has just never come up? The answer, of course, is that while the trial lawyers have been aggressive in pushing all of their rights, there are very few issues regarding toxic torts or medical malpractice or product liability that are undecided. But when it comes to subrogation, we have a lot of undecided questions because we haven't pushed it, because we shy away, because as we'll talk about later in just a few minutes here, and I'm going to try and finish by 9:30. We don't value subrogation enough to invest in it. We don't take those cases which have good facts and try and turn them into good law for subrogated carriers. In fact, sometimes we take the cases with bad facts and push them and end up with catastrophic law. Lastly, there are limits on filing subrogation actions. Many of you have heard in Pennsylvania there's been a long line of cases regarding whether or not a subrogated carrier can file on its own, as they can in most states. Last year there was a case involving Liberty Mutual and a defendant called Domtar Paper Company, and it said that although Section 671, the comp subro statute in Pennsylvania, doesn't grant the carrier the right to bring suit directly, it can do so, quote, through an action brought in the name of the injured employee, either by joining the employer as a party plaintiff or as a, quote unquote, use plaintiff. Very interesting decision. Some states don't allow the carrier to file at all. New Mexico, West Virginia. Well, actually, New Mexico does not. West Virginia is actually undecided on that issue. So you can see we have lots of other subrogation obstacles. I'm going to briefly touch on construction settings because they do relate to borrowed servant, which is an offset of the employee leasing obstacle we discussed. But in a noble effort to now place construction workers ahead of subrogated carriers. Again, legislatures, and I'm ran for the legislature here. I lost by just a handful of votes, but I have been in local government for many years. government tends to listen to the squeaky wheel. They listen to the noisemakers. And trial lawyers have been noisemakers, and they've been listened to. And in Nevada, they have put construction workers ahead of work comp carriers' subrogation rights by arguing that when you have a general contractor and a subcontractor, they're going to consider both of them to be statutory employees. This is true in a lot of states. There's complicated rules and regulations with regard to when the exclusive remedy rule protection is going to be shared by everybody in the contractual chain, general contractor, subcontractor, owner. It all depends. But something that is coming up with some frequency, and by the way, most states require that you be in the same trade or profession, but that has been really stretched in a lot of decisions in most states. Wrap-up policies are becoming the vogue. Owner-controlled insurance programs where the owner goes in, everybody bids on the project, all the subs, and they include all their costs, including work comp coverage, liability coverage, yada, yada, yada. And then the owner picks the subcontractors, and they all back out all those insurance costs, and the owner goes and buys the insurance for everybody, which includes liability, auto, comp, builder's risk, those sorts of things. And then the states like Nevada decide that, well, everybody in this program is going to be considered a statutory employer. We're just going to paint with a really broad brush the entire chain of contractors as all being employers. Again, extending the exclusive remedy rule and bending it in ways that the originators of work comp and that social compromise never foresaw. Contract, CSIPs, contractor controlled insurance program, same thing as OSIPs, except it's the contractor that does the work. So I understand this has been sort of a rough, brief overview of these obstacles, but now what does that mean in terms of where is it good to subrogate and where is it bad to subrogate? I want to talk about, again, something I've never done, and I took the time to come up with a list of, and this is after 33 years of doing work comp subro in all 50 states and the District of Columbia, and actually having a voice in the fashioning of some of the work comp law and many of the Supreme Court and Court of Appeals opinions in many of these states. I think I have a pretty good grasp of which states are good and which states are bad. Now, what makes a good state or a bad state? It's a combination of laws that affect work comp recoveries. Like I said, this is a huge mosaic. You can't look at one state and say, oh, they have made whole. Oh, they don't. They're good. They're bad. Made whole laws play a big role. So in looking at this, I've looked at states that have rules which apply equitable distribution or other artifices which apply the made whole doctrine to work comp recoveries. I've looked at the availability of future credits and how that applies. I've looked at lien reduction statutes, which states have those. A big factor, no-fault laws. Has nothing to do with work comp, but it does affect significant recovery potential in actions involving automobiles. Limits on rights of intervention and participation, like Florida. Those are big factors that affect our ability to protect our interests. One of the rules we should always remember, and you should walk away from this webinar with, is never, never, never let the plaintiff's attorney represent your interests unless you've got just a few pennies you're trying to protect, because their job, their ethical responsibility is to screw you out of your subrogation dollars. That's what they are there for. If they're not doing that, they're not doing their job. I look at notice requirements, intervention mandates, employer contribution laws like in Illinois, attorney's fee considerations. We haven't even touched on the ability of the attorney for the employee to take part of your lien. One second. Again, my apology, I got a drink. We also look at the laws regarding what you can recover from. I give a webinar on work comp subro in Wisconsin. Just Wisconsin. It's 4 hours long. I mean, there is so much meat on the bones of the subject we're discussing that it's almost unfair to try and touch on these things in a 90-minute session. But I look at recovery from potential third-party sources, UIM, legal mal, med mal, all sorts of things. And what I've come up with is that out of all 50 states, Wisconsin is the best state. Wisconsin has the automatic formula that's followed. You cannot break the formula. It ensures 100% recovery for the employer, the subrogated comp carrier, when there's sufficient money involved. In other words, it's possible that the employer might recover a reduced lien, but if it does, that means the employee is recovering even less. So the formula is followed. Claimant cooperation is ensured. There's no attorney's fees paid to the plaintiff's attorney, no allocation of elements of damages, no gerrymandering, no application of made whole, and you can even, in some cases, recover attorney's fees, and I love this, out of the trial lawyer's fee, where you've been active, where you, the people listening to this webinar right now, where you are active in doing discovery, getting statements, doing investigation, and I turn that over to the trial lawyer and he uses it to his benefit, I can charge him for it. And I have often sent clients checks for amounts far in excess of the work comp liens, and that excess does not represent a credit. That credit is above and beyond which the Wisconsin law applies, but it's actually just free money. So Wisconsin is a very favorable state. No state is perfect, but Wisconsin is close. Alabama, we have first money rights. The employer is immune, even if there's an intentional act. It has a lot of good stuff going for it. Other good states, Delaware, Maine, Wyoming, Iowa. Iowa has a few glitches. You got to be careful under 8522 whether you settle a work comp case. Make sure the language is there, or you could end up waiving your lien, but overall it's a great state. Hawaii, who would have thought? Maryland, Rhode Island. Okay, these are far east states. They're blue states. You'd think they were very, very strong trial lawyer, but they're also very, very strong labor. So there's a trade-off there. And these are the top 10 states for work comp subrogation. If these states aren't given some deference when it comes to underwriting and premiums, they sure should be. The worst 10 states, Georgia we've talked about. We know about the problem there, codification of the May-Hole, all kinds of problems. And Florida, a bad state, you can't intervene, you're simply a bystander, and when you do get your money, it's basically cut to shreds. You recover pennies on the dollar under the Manfredo formula. We have ways in which we combat that. We have argued for intervention and succeeded in certain cases, but it's very, very rare. Illinois we've talked about. We know it's very expensive to subrogate there. You have the chance for fresh money the employer pays. You have contribution of the employer. Defense counsel often has a conflict if they want to represent your subrogation interest. So just keep that in mind. Other states that really, really suck for work comp subro, Kentucky, California is horrible because, I mean, the dollar recovery is there if you want to put in the time, but they can settle around you in California, which is problematical. And so you have to be prepared to try the case at any moment, even days before trial. So we have a system down for that, and we have local counsel out there. Massachusetts, Louisiana, where they have the limitation of 50% arbitrarily. Michigan, now Michigan's in here. Their work comp subro statute isn't horrible, but of course, half the injuries you see are automobile accidents, and I don't have to say much about the failed experiment of no fault, especially in the biggest no-fault state we have, Michigan. Minnesota has the Lambertson formula. They have contribution there, much like Illinois does, and then New Mexico. So these are the worst 10 states, and I would ask you to commit them to memory because these are states that really their employers should be told, hey, write to your legislator, because unless they change some of these horrible, horrible laws which hurt subrogation, we can't use that subrogation to hold down your premiums. Explain the experience mod to them, and there's articles on our website. We have a great one that we use for self-insureds and large blue chip accounts where you can explain the experience mods and all of that. So I want to go through just a couple of trends in general. You guys can send as many emails as you want with questions after the session's over here in a few minutes, and some of these may set off other thoughts, questions you may have, but there's the decline in claim frequency is slowing, and I'm talking about work comp in general. Injured workers are off work longer. This has to do with mainly doctors. I think there was a study, over 20% of lost time from work injuries could be eliminated if doctors are given sufficient information about transitional job possibilities. The economy also plays in this. Medical costs are rising. I've written articles on Obamacare and really why that's a stepping stone to something else, but in the meantime, it's not going to produce better healthcare coverage. I wrote a book called ERISA and Health Insurance Subrogation in all 50 states, and there's a chapter dedicated to that. By the way, 3.8% of physicians involved were responsible for 72% of the costs, so there's a doctor component to this. Independent contractor misclassifications, again, this doesn't have to do with barred servant or temporary employee situations, but in underwriting, when you're getting your employers or your potential insured's employee classifications, it's now common that they'd be misclassified. 21 states have passed new laws making it easier to force employers to reclassify contractors as employees. And of course, there's 11 states have passed laws that curtail the use of independent contractors or increasing penalties for misclassification, including California, Connecticut, Florida, Maine, Nebraska, Wisconsin, Vermont, Pennsylvania, others. Wrap-up policies, we talked about this. This is a growing trend, and of course, every time you see those letters, they should translate into reduced subrogation and reduced subrogation opportunities, because that's often an afterthought. Medicare set-asides, of course, has been evolving. There's been good news with the 2013 passage of the SMART Act, but there's a long way to go. I commend Medicare for recovering its money. It's often like Jehovah's Witnesses come to my door, and my first thought is, oh, crap. And my second thought is, wow, I really admire those guys because they are aggressive. They're out there doing what their faith leads them to do. Well, you know what? I'm not a big fan of CMS or the system of Medicare, but I do commend them for getting their money. I wish many in our industry would be as aggressive as they are in trying to recover back their dollars. Working at home is a big trend, and this is just for work comp in particular, not work comp subro. And over 12 million Americans are performing their duties at home, and that produces all kinds of different issues, premises liability factors that risk managers can't assess. So that's complicating things. And then again, there's Obamacare, and I could do an hour on that. The war against subrogation is something I've been talking about. Obviously, I'm passionate about it, and obviously I've seen first line. I've seen on the battlefield how it really does affect subrogation. I see dozens every week of large cases which are harmed because of anti-subrogation legislation, and as a result, I think we need to have a call to action. We have to really stand up for subrogation. By the way, if you're interested, I appeared on national radio. There's some 425 radio stations that picked up a debate between me and a law school professor out of South Dakota, I think, named Roger Barron, on the values of subrogation. He, of course, is a trial lawyer tool and had a completely different view on it, but I think you'll find it interesting. I think it's still on the website and can be linked to and listened to. If not, Jamie will yell at me and tell me it's not, but I think it is. So, okay, she says it is. I heard her yell. Subrogation education, this is what we're doing here. Lobbying, this is what we're not doing. Often I'm the only guy sitting on the right side of that aisle at these committee hearings trying to, and then I'm often asked, believe it me, but I'm often asked, well, where's the insurance representatives? And I just kind of have to make something up. We have to employ aggressive and creative subrogation policies. This is where we think our strength is, and this is the story I told you about the New York, the Texan in New York who got the loan, and we have to be creative in the way we handle these things. We have to avoid cut rate vendors. I represent a lot of them, so I have to be careful. But guys, if it sounds too good to be true, it probably is. put my name and the word cut rate vendor into Google once, there'll be a great article that I put on Claims Journal where I have a column. I have a column on Claims Journal. I have a column on CLM, all dealing with subrogation, and in many cases just work comp subro. We have to increase premiums in those 10 states and many others which are bad. We have to help the states that are good. We have to charge appropriate amount for waivers. It's an afterthought. We have to recognize the insured's interest in subrogation and let them know that. My goodness, this is a wonderful marketing tool. Subrogation is not only a tort reform tool, we talked about that earlier, but it's also a great marketing tool for your clients and your insureds. Heck, we're out there getting your money back. Not only do we pay out for you when you owe, but then we get your money back for you. So we do need a call to action, and subrogation is an investment. I see insurance companies, I run a business. I watch pennies. We all have to do that, but there are some cases in which the pennies, we're stepping over dollars to pick up dimes, and I think we have to be careful. Subrogation is an investment, and there are some cases that are worthy of pursuing that we're not pursuing. So future trends in work comp subro, and this will be very short and sweet. Trial lawyers are continuing to eat away at our statutory rights. That's a societal bargain that we cut 100 years ago. We have to invest the time and resources. We have to secure and shore up those rights. There's no secrets to success. There's no shortcuts. It's just like in sports. It's the result of preparation, hard work, learning from failure. We have to make an investment. We have to be willing to make the sacrifices. Nick Saban, by the way, I just enjoyed the national championship game, and I'm a big fan of Nick's. I'm not necessarily an Alabama fan, although I like their team, but he said, and I quote, "When you invest your time, you make a goal and a decision of something that you want to accomplish. Whether it's make good grades in school, be a good athlete, be a good person, go down and do some community service or help someone, whatever you choose to do, you're investing your time in that." So unless we fight these trends, we're going to see a number of states increasing all of the obstacles we talked about, employer contribution claims, reducing liens based on employer negligence, made whole, lien reduction statutes, court-crafted formulas. It costs us money, but more importantly, it costs our insured's money. More importantly, it costs small businesses throughout America money, and that hurts our economy. So if you can see me waving the flag, yes, subrogation is patriotic. I've never said that before, but listen, I really appreciate the time. I really appreciate the opportunity to speak to an organization as esteemed as AIA. It's a great organization, and I will be fielding all sorts of questions. And it's a little unwieldy to do this through the webinar. Thank you for allowing me to attend remotely. The next time I'll come out and speak to you personally if you still want me back after listening to this. So send your questions if you have any, and I look forward to hearing from all of you. Thank you very much. God bless. Bye-bye.